afternoon. Welcome to Law Power Hour. Today we are very fortunate to have Mr. Jerry Acker with us of the law firm of Goodman and Acker. And before I introduce Mr. Acker, I want to tell you something really important. You know how I'm always coming down on TV advertisers because I feel that they overreach when it comes to the law field. Well, I have to tell you, Goodman and Acker advertises, but they're in the courthouse. I see him around court all the time. I see his partner, Barry Goodman, in court regularly. They participate in our community. They're activist. They're proactive in certain areas. Last week, one of their partners was on straight ticket balloting. So they're engaged and involved in what's going on in the state of Michigan. And I want to thank you for coming today.
Well, I appreciate you having me here.
Tell us a little bit about your firm.
Well, we're 11 lawyers, and we've been practicing personal injury law for almost 30 years. My partner, Barry Goodman, is a past president of the Trial Lawyers in Michigan, as am I. And Mark Brewer's there. Mark does a lot of work with the Democratic Party, was the Michigan Democratic Party chairman for almost 18 years. And we've got a bunch of lawyers who work hard, and we're in the courthouse or in the courtroom representing people who need our help.
Now, that's a distinguishing feature that I want everybody in this audience to understand. They are in the courthouse. That means that they get dressed up and go to court and represent their clients at court. They're not on TV soliciting people to come into their office saying, we're going to get you a lot of money, and then turning that business over to other lawyers because they're brokering business and they're not practicing law.
No, we're not brokers of legal work. We actually practice law. I've been practicing for 32 years. I'm in the courthouse every week. We try cases, we arbitrate cases, we go to depositions, we argue motions in court every week. That's what we do. We are not brokers of cases. We will not show up on your door, knocking on your door unannounced. We do not do those things, and we don't approve of others who do it.
Now, with respect to your firm, if people in this audience want to call you, how do they reach your firm?
They call 1-800-TRUSTED, TRUSTED. That's all they have to do. They can look us up on a website, goodmanacker.com, or the phone number.
Well, that's pretty nice. They can call Trusted if they want to get a hold of you.
Yes, sir.
And do you have operators available 24/7 to talk to them?
24 hours a day, 7 days a week. There's someone there who will answer the phone. And while you might not get a lawyer there every night, if you call in the evening and you've got a problem, you'll get a phone call back.
So there are lawyers who are in contact with the people who take your messages and will reach out to your firm's attorneys at night to give a response to people.
We have a lawyer who is on call every night of the week and every day on weekends. If someone's got a problem, they can call us and they will get a lawyer.
Now, does it matter whether it's an area that you specialize in or an area where you can assist someone in finding a competent lawyer who can represent them?
Well, we'll do both. We do personal injury work. We'll do auto accident work. We'll do premises and fall work. We'll do medical malpractice. If it's something that we don't do, we will make sure that when people call, they will get to a person who is competent, who will deal with them honestly and decently for a reasonable rate.
Do you think that the Michigan Supreme Court's doing justice to the citizens of Michigan in the area of premises liability law?
I don't, actually. I think about 10 years ago the law changed, and they made it so that we didn't hold each person responsible for their own behavior. We decided if something was so bad that anybody should know about it, no matter what the owner of the premises did, that they're not responsible, and we don't think that's good.
So in other words, if there's an open defect on the property and it's been there for a couple of years, a hole, and I'm going in at night to my apartment and I trip in the hole, I can't recover because of what the Supreme Court did.
Well, in an apartment complex, it's different than anywhere else. But generally speaking, if it involves snow and ice, it's a problem. We talk to everyone who calls with those cases, and I encourage people to call and ask those questions, and not to decide for themselves that they don't want to talk to a lawyer. The call is free. It's worth your time if you've been injured to talk to someone and make sure that what you're asking and what you're thinking about is accurate. But the Supreme Court has made it a lot tougher than it used to be.
Now, in the area of premises liability, when you talk about snow and ice, is it true that the Michigan Supreme Court's attitude is that all of us know it's going to snow in the winter and there's going to be ice, so we've got to watch where we walk?
It's their attitude in a lot of areas. They think that if there's snow and ice in December in Michigan, that it doesn't mean no one's responsible for their behavior. We don't think that's true. We think that if you're running the McDonald's or you're running a store and you've got snow out there, then it's your obligation, if the doors are open and you're trying to sell something to someone, that it's your obligation to make sure that the sidewalk and the parking lot are clear and that you've salted it. The Supreme Court thinks differently.
Well, aren't there different classifications of individuals when it comes to premises liability?
There are.
Why don't you share some of that with our audience so they understand, depending on what activity they're engaged in, they might wear a different hat?
Sure. So there's a couple different categories. If you're going to someone's store for business, you're going to pay them, you're doing work there, they're doing work for you, you're called an invitee, and there's special obligations that the court places on the owners of the premises to make sure that it's safe. If you're going there because you're visiting a friend, you're just going to church, there's an activity called a licensee. It's not for money benefit, it's just because you want to go there, and there's a different set of standards for those. And then there's the trespasser, someone who's going on someone's property and they have no right to be there, and the law places the least obligation on the owner of the property when that happens.
Well, there's a lot of that trespassing issue that's been discussed in case law, if I remember correctly,
Yep.
dealing with sporting events or concerts where people sneak in, they don't have a ticket, and they get hurt.
Yep.
They can't recover, can they?
They can't. It's very difficult. Unless there's an obvious danger or an unreasonable danger, in which case they would have a duty to warn that person, they can't.
Now, what's the most important thing that you can tell our listeners if they have a premises liability case? What's the first thing they should do?
The first thing they should do is report it, take a picture, and call 1-800-TRUSTED. That's what they ought to do.
Now, after they report it, should they get a copy of the documentation?
Not necessary. But here I'll preface it by saying this: if you're hurt in an accident where you've fallen, you should get care. You should go to the hospital. You should see a doctor. You should make sure that you're taken care of, because in the end, all of us want to get better, and that's what our first obligation is.
Then you said take a picture of it.
Yep.
Why do you want them to take a picture of it?
Because a picture's worth 1,000 words. That's why.
Okay, and that's going to memorialize the incident, isn't it?
That's right. It's going to let people, when you go someplace later on and you try to explain what happened, it allows you to take the picture of either the hole in the sidewalk or the ice that's on the ground or anything that's occurred. That's what you want to do it for.
And would you agree with me, if you have that kind of information going in, you have a much better chance of recovery?
I think so.
And then you said that you go to the doctor and get treated appropriately, because medical treatment's really important, isn't it?
That's right, it is. It's, falling and hurting yourself and never going to see the doctor is a lot different than falling and hurting yourself and the doctor has to fix a leg or fix an arm or do surgery on you. There's a big difference there.
Most of the time when people slip and fall or trip and fall and they have a horrific injury, like they're knocked out, they have a broken leg, they're already rushed off to the hospital in an ambulance before they have a chance to give the owner of the premises notice.
That's right.
How do you remedy that situation?
Well, if you've fallen and there's an ambulance that comes and gets you, well, there's an EMS record that shows that you were at the premises that day. Lots of different ways that we can work it out. Your first duty is to make sure that you get taken care of. But if there's someone with you, if you're with a family member or a friend who can take a picture, or you can tell someone when you're in the hospital to ask them to go back and take a picture, those are good things to do.
Now, there are some defenses that the Supreme Court has used. They use these terms like open and obvious. Yep. Would you like to explain to the audience what open and obvious is really about?
Well, sure. So the Supreme Court has decided that if a defect, not in every case, but in some cases, where the owner of the property is in possession and control of it, and the defect was open and obvious, that they're not responsible.
In other words, if I'm walking along and I see a trip hazard when I'm going into the store, I'm put on notice at that point that there's a trip hazard?
Well, I think the Supreme Court's position is it's common sense that if you're walking down the street and there is a trip hazard, you ought to walk around it, or at the very least, you ought to look where you're walking to make sure that you're safe.
What happens if there's only one means of ingress, one way of entering and one way of exiting? What happens in that situation?
Well, in those situations, there is a higher chance of being able to recover. There are exceptions to the open and obvious rule, and sometimes we can work that out for him.
Okay, now in terms of the need to contact a lawyer, would you agree with me that especially in situations involving premises claims, that one of the first rules is to contact a lawyer to get some assistance in perfecting your claim within the first week?
Well, I would tell you this. I would tell you that if you've fallen at a store, I guarantee you that the insurance company of that store is going to have their investigators out, and they're going to be trying to do everything they can to prevent you from recovering any money. So the smart thing for you to do, if you've fallen and you've been injured, is to make sure that you have a lawyer on your side preserving the evidence to show that they were at fault.
You know, over the years I've noticed when people slip and fall in the grocery store, for example, that the insurance carrier for the grocery store would have one of their representatives contact my clients.
That's right.
They want to stigmatize them.
That's right. They want them to commit to what happened before they've even thought about it, before they even recovered from their injuries, and they're working very hard to make sure that the person who fell and was injured doesn't recover any money whatsoever.
So would you agree that as a rule, this listening audience and every person who may have a claim should not give a written statement without consulting a lawyer before making that statement if it involves an injury claim?
I would agree that every person should think long and hard before giving a recorded statement or before signing anything. I think that it makes sense, though, at the beginning that if you're injured in a store and you're down on the ground and the manager comes, that you give them your name and address so at least they know who you are and that you can document that you were at the store that day and that the accident was real and it wasn't fake.
Thank you. We're going to take a break for a moment. We'll be back. We're going to talk more about the law with Mr. Acker.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. Know your rights. Watch Law Power Hour, hosted by Barry Keller, attorney at law, Tuesdays at 5 p.m. here on WHPR, Detroit Live.
We're back with Jerry Acker again from the law firm of Goodman and Acker. We've been talking about premises liability, and now we're going to talk a little bit about the state with respect to automobile injury claims, first party and third party. Now, you advertise for those claims, don't you?
We do.
And there have been some major changes in the last few years in first and third party cases.
There have.
Now, with respect to first party claims, you have how much time to make that claim from the date of the accident?
Well, there's two parts of a claim when you're involved in an auto accident. There is the economic side, your lost wages and your replacement services and your medical care and those things. And then there's the case against the other driver, your pain and suffering. Against the other driver, you have 3 years from the date of the accident to file a lawsuit. And against your own insurance company, you have 1 year to present the claims and file suit.
Now, with respect to presenting the claim during the first year, do you believe that every person who's involved in an accident needs the assistance of a lawyer for a first party claim?
Most of the time I agree. There are occasions when it's not necessary. It's few and far between because the insurance company is always trying to figure out how to take advantage of you. But there are cases occasionally where I'll tell someone you can handle this on your own. You've only been missed work for a couple of weeks. They're voluntarily paying you for that. You don't need to pay me for that work.
Okay, now, Goodman and Acker, when you advertise for first party claims and people come to see you, do you always sign them up when they come in, or do you give them an opportunity to go out and handle their own claim first and see how they do?
We give them an opportunity. We give them both sides of the equation, let them decide for themselves. We think that people are entitled to have good explanations of what's going on so they can make their own decisions.
So if they go out, have an accident, and they want to call your firm,
Yep.
They're going to call what number?
1-800-TRUSTED.
And I can assure them that your attorneys will sit down and explain the law and the procedures to them and not force them to sign a document at that time. Is that true?
That's right.
And give them the opportunity to handle their own claim.
That's right.
The reason I'm asking you this, it's real important. It's because I've been so outspoken about this on the air that I feel that people who were victims of accidents are being victimized by a lot of attorneys.
I think that there are some lawyers who are not straight about what's going on. I think there are some lawyers who are invested in medical providers and they're getting money on both sides of the equation. I think it's far and few between, but I think there are some. And I think that people ought to be thoughtful about what they're doing. If there's somebody knocking at your door after an accident and you haven't called them, those are the people not to open the door to.
Now that happens in our community, doesn't it?
Unfortunately, it does.
How often do your clients that call you and look for your firm tell you that they've been contacted by a half a dozen strange individuals through the telephone, are knocking on the door, want to take them off to a physician, a chiropractor, or a clinic for treatment?
We hear that all the time. But here's even better. We hear about people who are in the hospital and they'll have lawyers walking into their room in the hospital while they're under sedation trying to get them to sign up. Those are the kinds of things that we've been fighting, Barry and I, as leaders in the Michigan Association for Justice for the last 10 or 15 years, trying to get laws enacted to stop that kind of stuff.
Well, we have not really been successful in getting those laws passed, have we?
Well, we've been successful in getting one law passed, but the same folks who are knocking on the doors and walking into hospital rooms also have their connections in the legislature and have been trying to prevent that.
Didn't we have a period where we had a cooling off?
Yep, there was supposed to be a time period for the first 30 days after the accident where no one, unless you're involved in the accident or you're the police, are entitled to get police reports. But there's a group out there who have been buying police reports and sending people out to folks' homes and to the hospitals to try and talk to them.
They remind me of diggers who are out there scalping tickets for football games, you know?
They're the folks who give lawyers a bad name, and it's a shame because most of the lawyers that I know work hard, play by the rules, and work hard to represent their clients.
Do you make house calls at your firm?
We do.
Do you think it's a good idea to make house calls to injured victims?
I think folks who have transportation issues, who can't see someone, who are calling me because they want me, I think that's okay.
And when you send somebody out from your firm, are they going to get an attorney from your firm, or are they going to get an investigator who's going to come out to the house?
They're going to get both, depending on the circumstances. Most often they'll get an attorney, or we'll meet them someplace, or we'll meet them at the hospital, but they're going to get a lawyer and a paralegal to come and see them.
And then when you sit down and talk to them about the case, tell our listeners what you're going to tell them about automobile no-fault law.
I'm going to tell them that knowing the law is an important thing, and that doing it by yourself is not a thoughtful thing. That the insurance companies are not there for your protection, they're there for someone else's protection, and they're there for making money. And making sure that you have fair and honest representation is a good thing.
You know, it's amazing to me. You and I have contracts with insurance companies. So if I'm involved in an accident, by contract, the insurance company's supposed to pay me, aren't they?
That's right.
And the insurance company's fighting with me, and I'm paying their salary.
That's right. They are. Because in the end, the insurance company may have a contract or an insurance agreement with you, but the reality is they have shareholders and stockholders, and they want to make money.
Insurance companies are in business to make money, aren't they?
That's right.
Are they losing money because of no fault?
Nope. Casinos and insurance companies are the two biggest profit makers in the country.
And who suffers? The victims of accidents, correct?
That's right.
And that's why we have organizations like the Trial Lawyers, isn't it?
That's right.
How long have you been active in Trial Lawyers?
I've been active with the Michigan Association of Justice, and before that it was called the Michigan Trial Lawyers Association, for almost 25 years.
You know, back in '74, we passed a no-fault act.
Yep.
And why was it passed?
Because we didn't want people who were injured to have to fight with insurance companies. We wanted to set up a voluntary system where if you were injured, that you wouldn't lose your house or wouldn't lose everything you had because you were trying to make medical payments. So we set up a system so that you could get care, that you could get your lost wages taken care of, that you could get your nursing services taken care of, and that you wouldn't lose your life because of an auto accident.
Now, if anyone out there who has questions about how to handle their claim, you can call Goodman and Acker.
1-800-TRUSTED.
And they will answer your questions about your injury claim.
That's right.
Now, let's talk a little bit about first-party benefits. We know that you're entitled to receive medical care and treatment, correct?
That's right. For the rest of your life, whatever is reasonable and necessary.
Now, I've heard recently that there's a whole group of lawyers who are settling future first-party claims.
Yep.
Explain, please, to our audience what that means and why they shouldn't do it.
Well, if you're involved in an auto accident, you're entitled to your lost wages for up to 3 years after the accident. You're entitled to care around the house for up to 3 years. And you're entitled to your medical for the rest of your life that's reasonable and necessary and related to a motor vehicle accident. So if you're settling out your future, you're not getting paid for it, but the lawyer's getting paid for it. If you're settling out your future medical benefits, that means that 5 years when you've got a problem or 2 years when you've got a problem, there'll be no one there to take care of you, but the lawyer made money on it. So it's our practice, for the most part, not always, because there's exceptions to every rule. It's our position that you should never settle out your future benefits. It's not in your interest to do it.
Okay, and those first-party benefits, we have replacement services. Do you think that the rate that we're receiving today, you and I, if we're victims of
Sure.
accidents, is a reasonable rate for replacement services?
Well, back when you started in 1974, it was $20 a day for replacement services. Today, it's $20 a day, 42 years later. $20 a day right now is about $4.25 in 1974 dollars. And the legislature, in protecting the insurance companies, has prevented an increase in that rate for all of these years. But not only that, the minimum amount of insurance you have to protect yourself if you've injured someone else is $20,000. That stayed the same amount for the last 42 years. There's not been one increase in that. And I tell everybody who comes in that the most important thing that you can buy for just a few dollars a year is something called underinsured motorist protection. And literally it is $10, $12 a year, and you can buy yourself an extra $100 or $200 or $1 million worth of coverage to protect yourself against somebody who's not properly insured.
Would you agree with me that there's a category of individuals who are involved in an accident who are the most victimized in our entire state, and they possess motorcycles?
Yes. Yeah, and you'll laugh when I tell you this, but in Michigan, a motorcycle is not a motor vehicle, and it's treated differently under the No Fault Act, and you have to buy special coverage in order to make sure that you're covered.
That was my point that I wanted you to make, because if any of you are out there operating a motorcycle and you don't have a special rider, in other words, if you don't have a special attachment to that motorcycle policy for no-fault benefits, you can't get no-fault benefits under your own automobile policy. Is that true?
That's right. You've got to buy something called PLPD to make sure that you're protected.
So the best thing that you can do is get some guidance from this show and make sure the following. If you operate a motorcycle, what should you do?
You should make sure that you have the proper insurance, and if you're in an accident, call 1-800-TRUSTED and talk to me.
Okay, me. What's your name? Not everybody's been listening to this show. You better tell me your name.
Jerry Acker at 1-800-TRUSTED. And if you call my firm and you want to talk to me, they'll put you through right to me.
Oh, that's what I like, because it's important. You know, one of the other problems you just mentioned is called underinsured motorist coverage. That means if you're involved in an accident with a person who has less insurance than you and you have underinsured motorist coverage, what can you do?
You can buy the coverage and protect yourself. And then there's a second category, which is called uninsured motorist protection. And about 50% of the people who drive in certain areas of the state of Michigan don't have insurance, and you have no ability to sue them for money. So buy uninsured motorist coverage. Like I say, it's just a few dollars a year, but it's a terribly important thing to have.
Okay, we're going to take a break for a minute, but I want some of you to call in, because I've got an honest, responsible lawyer on here today who's going to answer your questions about injury claims. Thank you.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. Know your rights. Watch Law Power Hour, hosted by Barry Keller, attorney at law, Tuesdays at 5 p.m. here on WHPR, Detroit Live.
Now, we talked about first-party claims in the last segment. I want to switch gears and talk about third-party claims. And by definition, a third-party claim is when you're injured in an accident and someone else is responsible for the accident. What can you do?
Well, if someone else is responsible and you've been injured, you can file a claim against them. When in Michigan, we talk about the term no fault, and what we're talking about is no fault against your own insurance company for your economic benefits, but against the other driver, you have to show some fault, and we can file claims for them.
How much fault do you have to show?
Well, you show enough fault that it's somebody else's problem, and come see us, and we'll see if we can figure it out.
Does it have to be more than 50%?
Generally speaking, it does.
If it's more than 50%, you can recover what?
You can recover for your pain and suffering. And that pain and suffering means not just today, but tomorrow, and what's going to happen to you the rest of your life as a result of the motor vehicle accident.
Suppose that I have an accident and I'm permanently incapacitated.
Yep.
I draw my no-fault wage loss benefits for 3 years.
Yep.
Someone's paid the $20 a day, which we've already discussed and we don't like. I have somebody taking care of my attendant care, making sure that I can bathe and dress myself.
That's right.
Can I make a claim for any of those benefits after the 3 years against the at-fault driver?
You can. And not for your attendant care, because that's part of your medical benefits that goes on the rest of your life. But replacement services or lost wages in excess of the 3 years, you can file a claim, and that's part of your claim against the other driver.
Now, let's talk about what you have to prove today in order to have a third-party claim.
Sure. In Michigan, there's 3 different categories in order to file a claim against the other driver. If you've died, you have a right to file a claim. Your estate does. If you suffered a serious permanent disfigurement, scarring of some sort, you have a right to file a claim. Or if you suffered what's called a serious impairment of body function, you're entitled to make a claim against the other driver.
Okay, now in terms of death, there's a lot of survivor benefits that you're entitled to receive under the No Fault Act, aren't there?
There are, against your own insurance company. And again, that's part of the no fault process. So whether you're at fault from the accident and you die, or if someone else is at fault, you're entitled to recover those benefits.
Under the No Fault, you can recover burial benefits, you can
Yep.
recover replacement service benefits,
Yes,
you can recover lost wages, right?
that's right.
What else can you recover under the No Fault side?
You can recover, I think those are the 3 things that you can recover. Your burial benefit, your lost wages, your replacement services. If there's any medical benefits that came from your last event, you're entitled to recover that.
Okay, but then on the third-party side, is there a ceiling on how much I can sue for as a result of the accident?
Well, there's no ceiling, but there is a certain reality that goes with auto insurance law. And if you have someone who's not making a lot of money and they've only got a $20,000 insurance policy, that's generally a ceiling. And that's why we talked earlier about it, and I tell everybody every day, is make sure you have underinsured motorist protection, because the amount of insurance that you buy is what the ceiling is. So if you spend an extra $30 a year and you buy $1 million worth of coverage, that becomes your ceiling.
Otherwise, you're limited by the amount of insurance the other party has.
Unless there's a cash cow out there someplace, that's right.
Now, in terms of the second category, disfigurement,
Yep.
there's some rules which I really am not sure whether they make sense about disfigurement, because everybody looks at themselves differently. And it's very difficult for me to tell someone that they don't have a disfigurement if they have a disfigurement. How do you handle this process?
Well, we talk about serious permanent disfigurement as scarring. And scarring on your face, your hands, your legs. And depending on what you're showing off all day long, it depends for you. If you're a woman and you wear a dress and you have a scar on your leg, it's a lot more significant to you than it would be to me if I'm wearing pants all day long.
Suppose I'm involved in an accident and I need surgery, and as a result of the surgery I have a scar. Can I make a claim for that scar for disfigurement?
Absolutely. That's part of your claim, and that's part of the disfigurement that comes with your auto accident. The damages and the injuries that arise from the motor vehicle accident are what you're entitled to recover.
So it can be an indirect part of the claim.
That's right. Sure can.
It doesn't have to be directly related to it, but it can be a consequence.
That's right.
Okay. Now, let me ask you this. In terms of the serious permanent impairment, which is, as we call in the law, a play on words, what does it really mean?
Well, in Michigan, over the last 42 years since No Fault was enacted, it's meant different things at different times. Today it means is that you have an objective manifestation of an injury. That means it's not just something you're telling someone, but that a doctor has run a test or done an examination and says that you have something going on, and that it's changed the course of your life, whether it's that you can't work, or it's that you had 6 months off, or it was something that was initially very serious, you were hospitalized for a few days. Those are the kinds of meanings that we get to when we talk about serious impairment of body function.
You know, I found, and maybe you can correct me, that it's very, very difficult to get your clients to open up and talk about the things they really like to do.
Yep.
And isn't it important for them to feel comfortable so that they can develop a relationship with you and communicate about the things that are important in their life.
It's really important. And when a client comes to our office for the first time and signs up with us, they'll get a logbook. And what we encourage people to do is not just tell me that day that you're in the office or tell me when you come in for a deposition, but to keep a diary. And when you're laying down on the couch and you're trying to get up, or you're doing something and you can't, or you're with your spouse and you want to be together, and there are all of those things that go on that you just wouldn't tell. If you keep a diary, it's something that will help and help you maximize your claim.
Now, in certain areas, I had a client call me the other day, and she was having a problem in terms of being close to her husband.
Yep.
So she said, what should I do about it? I said, I want you to discuss it with your doctor. And your doctor will give you some suggestions on how to handle this situation.
That's right.
And that way it'll be documented in your medical records. So the message is communicate with your attorney and communicate with your doctor.
That's right. And there are times to keep your mouth shut, and there are times to talk. When you're talking about how you were hurt and how it's affected your life, talking to your lawyer and talking to your doctor, with the doctor to help you get better because they'll have good suggestions and advice. And when you talk to your lawyer about those kinds of things, that's something that helps us maximize your claim.
Now, in terms of the impairment of bodily function, by definition, does it mean that I can't work?
It doesn't mean by definition that you can't work. It means by definition that there has had an impact on your life. It means that you didn't have an auto accident and went to the emergency room and never saw anyone again because you were fine. If you're fine, God bless you. You should be fine. That's the goal that all of us should have, is that if you're in an accident, not to be hurt, because that's the last thing you want. But if you are hurt, then it's important to go and get treated and to talk to the folks who are about it and make sure that you get better.
Now, don't you think it's important for people to tell you what their hobbies are and their interests are so that you get a better feel for the people, better understanding?
I do, because it also tells you about the impact it's had on someone's life. If you're somebody like me who played basketball all your life and you couldn't play ball, that's a big deal. And it may not be a big deal to someone else who never played ball, but to me it is. And those are the kinds of things I need to hear from people and that I ask about and that we talk about.
Okay, so when you measure serious impairment of bodily function, it's not just the incapacity to go to work every day and do a job, is it?
That's right. And for some folks who don't work, it's the incapacity not to take care of the house, or not to mow the lawn, or not to be able to drive or play with a grandchild. There's 100 different ways it affects people's lives. But I don't see everyone all day long, and I haven't seen them for the past 10 years. So when they come to my office, I want to talk about it. I want to hear what they have to say and what their life is like.
Now, the courts have really been crazy in their decisions in this area, haven't they?
They sure have.
For example, there used to be a point in time, if you could go to the grocery store and you had to unpack the groceries at home, but you couldn't take out the bags the way you used to, as long as you could take the groceries out of the trunk of the car and get them in the house, that didn't constitute a serious impairment, did it?
That's right.
Has that changed?
Well, it has changed. And what's changed over the last 4 or 5 years is that the courts now, for the most part, allow juries to make these decisions. In Michigan and across the country, we have a Seventh Amendment right to a jury trial. And it's what's important to make sure is that you have that jury trial, or you have the right to do it. And when you have the right to go before your peers, it seems to me that it's much better for families and for the law in Michigan.
So you can address all of those issues and how your lifestyle has changed.
That's right.
For example, if you want to take a shave and you've hurt yourself and you can't stand up and you have to sit down, would you consider that an alteration in your lifestyle?
I would. I think for men who can't shave, who can't lift their arm above their head, for women who can't comb their hair, there's a whole group of things that happen in people's lives that are important and that lead us to conclude that someone suffered a serious impairment and we should go forward with a claim.
How many times have you had a client tell you they have difficulty brushing their teeth?
You'd be surprised. People who have shoulder injuries, torn rotator cuffs, those kinds of things, that's a pretty common thing.
And difficulty, turning their head.
Yep. Cervical injuries are a significant problem that happen, and we kind of kid about it, and they're talked about in the news media as whiplash. But what whiplash is a sudden jerking of the head back and forth, and quite frankly, we're not accustomed to, and it's not something that should happen, and it causes cervical and disc injuries that are really serious.
Do you think the medical community, by and large, has a captive audience when individuals are involved in accidents, and they can do almost anything that they want to do with the claimants in terms of medication, pain clinics, diagnostic testing.
Well, 50 years ago, doctors got a Blue Cross and Blue Shield card, and it changed their whole lifestyle, and they became wealthier and as part of the community. In the old days, doctors used to get paid with cash and with chickens and pigs and whatever else needed to be done in order to take care of families. And in our state, when we have Blue Cross, which is a godsend for most families, doctors got a credit card in order to take care of you. Under the No Fault Act, there are doctors who are wonderful, who truly care about their patients. But then there are some who are interested in the money, and you have to be careful about what you do.
And how do you investigate doctors for your clients to ensure that they're going to quality doctors? Because I know you want them to go to quality doctors, don't you?
I do. And I don't want to send them to doctors, and I don't want them, going to the doctors who are knocking on their doors and sending runners and chiropractors who are doing the same thing. We can't have that going on. So there are good ways to make sure when you come into my office and you have a list. I know the doctors who you should not be treating with, and I'm happy to tell folks that. But for the most part, the clients that come to us come through hospitals. They've gone to an emergency room. The emergency room folks have either sent them back to their real family physician or sent them on to an orthopedic or a neurologist to take care of them. So we see a lot of that.
Would you agree that one of the most important things for an individual who's involved in an accident, if they've gone to the emergency room, the next appointment after the emergency room should be with their family doctor if they have one?
Either their family doctor if they have one, or the doctor that the hospital's recommended they see as follow-up care.
A lot of folks don't have doctors.
That's right.
And they don't know where to go. So how can you help them find a doctor?
Well, what everyone should realize, whether they have health insurance or not, if they're involved in an accident in a motor vehicle, and either they are a passenger or they own the vehicle and it has insurance, that they have health coverage. And there's lots of good resources in order to get good doctors. You can call up the University of Michigan, you can call DMC, you can call Sinai. There's lots of good places to get referrals. Or when you come and see us, we'll have a list of doctors that are good and reputable in the community and that we can help you with.
So if I want to get that list, can I call your office?
If you want to get a list of good doctors, you call my office and I'll get your referral sources to where you can go.
And give us the number where they can call.
1-800-TRUSTED.
We're going to take a break for a minute. We're going to come back and talk a little bit more about these issues.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. Know your rights. Watch Law Power Hour, hosted by Barry Keller, attorney at law, Tuesdays at 5 p.m. here on WHPR, Detroit Live.
We're back on the air, and we just took a break. We were talking about third-party claims. I know your firm handles other injury claims besides automobile and slip, trip, and fall claims. What are some of the other areas?
We do. We handle medical malpractice claims, and we have a Social Security department, and we can take care of all those things. And the other thing that we're doing for teachers and other members of the community are disability benefit claims, long-term and short-term disabilities that they might have through a union in order to make sure that you're taken care of.
Well, those are three areas that I have a little familiarity with.
Yep.
And the long-term disability claims, as I understand it, they sort of tightened it up a little bit in terms of making those claims, because you have to almost prove that you can't perform any physical activity to recover today.
Well, those are on Social Security claims, and Social Security claims mean that you are disabled from doing any job in the community. It's not that you're having a bad day on Thursday, but you're literally not able to do any job. And it becomes easier to make those claims as you get older, if you're over 50, and it's easier to make those claims if you're less educated. But those are Social Security claims, and the government has tightened it up just a little bit.
Do you think in our communities in Michigan, where they say we have low unemployment, that it's really a fiction because people are substituting Social Security, disability for unemployment benefits because they can't find jobs?
I don't know that I would go there. I think that people who are getting Social Security are disabled. And I think the system is proper and it works. I don't think that you can get unemployment benefits unless you're ready, willing, and able to go to work. And there's a difference between Social Security and unemployment benefits.
Okay, now in terms of your Social Security claims, do you take those claims from the very beginning of the claim and initiate the whole process for the clients?
Sure. So we do Social Security claims on a contingent fee. That means you never get charged unless we're able to get you Social Security benefits. But if you're interested in filing for Social Security, you can call my office at 1-800-TRUSTED, and we will take you from the application process right through the conclusion.
And when you do that, do you walk them through the whole process?
When they call us and they get us on the phone, we will take them through the entire process, and we will most likely have your claim filed for you that same day.
Now, in terms of short-term and long-term disability, you said that you're working with a lot of teachers.
That's right.
Are those benefits generally paid through state retirement?
No, those benefits are generally paid through contracts that teachers have through their unions with school districts, and they provide long and short-term disability if you're injured or if you're unable to work.
And in terms of the medical malpractice, I know that statistically there's a very low recovery rate in medical malpractice in Michigan. Isn't that true?
Well, there's a lower recovery rate because the reality is that bad results don't include medical malpractice. The reality is that all of us grow old and we're going to die someday, and sometimes we die from real things, and it has nothing to do with doctors. But lots of times it has to do with doctors and hospitals and the care that you receive. And if they call my office at 1-800-TRUSTED, they'll get an outstanding medical malpractice lawyer who will help them through a process and let them know whether they have a claim or not.
Now, in Michigan, there's a whole procedure that you have to go through to file a malpractice claim, isn't there?
That's right. In Michigan, you have to give the doctor or the hospital 6 months' notice that you're going to file a claim, and at the same time, you have to provide the names of the expert witnesses who are going to testify against the doctors and let them know that information before you can file a claim. It is a process in Michigan.
It's expensive to file a malpractice claim in Michigan, isn't it?
It is. And if your malpractice is that you don't like how the doctor talked to you, or that you have a hangnail, those aren't medical malpractice claims that we can handle. You have to have suffered an injury in order for us to take the case.
Now, you told me before we went on the air that you went into the law because you didn't want to be a doctor. Is that true?
That's right. I come from a family of doctors, and I wasn't one of them.
Did you have an interest in medicine at all growing up?
I had an uncle who was an orthopedic surgeon, and he used to take me down to the hospitals, and I'd go see his patients with him, and I loved doing that with him. But it wasn't something that I was interested in. I was interested in the law and in politics and in history and those kinds of things, and that's why I became a lawyer, and I like taking care of folks.
Social workers take care of folks. That's what my dad used to tell me all
Yep.
the time. But lawyers do it because they have tools that social workers don't have. Isn't that true?
They do, but part of it is not just practicing law, but I'm part social worker. I've got families who've got problems. If you've been injured in an accident and you lose your house and there's a mortgage that's behind, those are all social work problems that we work with families to work out.
Okay, so, and this is really important, Goodman and Acker gets engaged in your life. Is that true?
That's right.
Because they're willing to go that extra mile.
Because we're partners in trying to help you fix the problems that have been caused by someone else.
And when people are injured, their lives are a mess. Your life and my life would be a mess just like theirs,
That's
wouldn't
right.
it?
That's right.
So we've got to help them, right?
That's right. Well, I tell folks this. The people in my life that I love the most are my wife and my kids. And, what I expect when I go to a doctor or I go to a lawyer is that I can say, what would you do if it was your mom or your dad or your child? And that's the answer I want to give folks. When people come to me, I want to take care of them like I would take care of my son or my daughter or my family member. That's what they're entitled to. That's what they pay me for. And that's what they're going to get at my office.
So if they come to you and they have credit problems while they're involved in an accident,
We work with them on that as well.
do you help them find financing if they need it beyond the no-fault benefits?
Well, the law in Michigan is that lawyers can't lend money to their clients, and that's part of the ethics structure that we abide by. I know there's some lawyers who might not do it that way, but we think that if we're lending money to clients, the client's going to say, are you settling my case because it's in my best interest or your best interest? And I want them to always know that we're always working in their best interest. But if they have those kinds of problems, there are places that we can get them to that can help.
Are there good people that you know of, if someone's involved in an accident, who can actually help finance some of the expenses that they've incurred so that they can pay their bills and continue to recover?
There are people who lend people money who have been in accidents. They charge an enormous amount of money. It's very, very expensive. I never recommend it unless you're in a terribly dire circumstance and you need the help. And under those little bit of circumstances, we'll try and help someone.
I have an interesting question to ask you. Suppose I've got a lot of debt and I'm involved in an accident. I can't go to work. I can't pay my bills. I get my first party benefits. I'm getting my wages. It's 85% of my wages.
That's right.
My medical bills are being paid for. And I got to file bankruptcy. What happens to my injury claim?
Your injury claim goes with your bankruptcy. So if you're filing it, if you're going bankrupt because you owe $5,000 in debt, it's not a great idea to file for bankruptcy. It's a great idea to wait it out and work to get your money and then pay your bills off. And that's what I recommend to people.
Why would my injury claim go into the bankruptcy court?
Because that's the bankruptcy law. Everything that you have goes into the bankruptcy. Your house, your cars, your money, your employment wages, they all go into the bankruptcy, and then the bankruptcy trustee will give you certain things back under the law. So that's why.
Do no-fault benefits go into the bankruptcy court?
They can go into the bankruptcy court. Your lost wages can go into the bankruptcy court. Your medical bills are owned by someone else, and they generally don't.
Does my disability go into the bankruptcy court if I'm drawing a disability insurance contract?
Well, there are certain limitations on what bankruptcy is allowed to, and you have to go through the bankruptcy process or at least talk to a bankruptcy lawyer to find those out. And if someone's got that problem and that's what's going on, if they talk to me, I'll make sure they get the best bankruptcy advice that they can.
Okay, now in terms of getting a hold of you or your partner, Mr. Acker, or anybody else in your firm, how do we do it?
1-800-TRUSTED. You can call Barry Goodman, you can call Jerry Acker, you can call my other partner, Tim Sololi, you can call my son, Jordan Acker, at 1-800-TRUSTED. We're there to help you, and we're able to take your calls whenever you need it.
Now, you're proactive in the community. I'm going to just spend a few minutes talking about this. Last week, we had one of your other members of the firm on straight ticket voting.
That's right. Mark Brewer, the former head of the Michigan Democratic Party, has been involved in making sure people get the right to vote and keep it.
And you're involved in politics as well?
I am. I just came back from the Democratic National Convention. I was a delegate for Hillary Clinton. And I've been involved in politics as a delegate for President Obama, and before that, John Kerry. And actually before that, I was a alternate delegate for Reverend Al Sharpton.
And how does that affect your ability to function as a good lawyer?
Well, I wouldn't say that it affects or improves my ability, but I know everybody. I know everybody who's involved in the process. I've got 30 years going in this. I know politicians, I know judges, I know people who have been involved in at the insurance company level. I know the lawyers. Part of what you get when you call Goodman Acker is that you're getting the fact that we've been around for a while and we know people.
And it's important in this business to know people and to handle the cases.
That's right, it is.
And I want to stress again, you don't broker out your business, you handle your business.
That's right. You call me, you get me.
Okay. Tell our listeners what that really means in terms of what they're going to get if they call your firm?
Well, if they call my firm, they're going to talk to me. They're going to talk to one of my partners. They're going to see us. We're not somebody who are on TV and you never see. You're going to see us in depositions. You're going to see us in court. You're going to see us, most importantly, when money decisions are being made and you need good advice. And if you call me at 1-800-TRUSTED, you'll get me.
You know, I have a question to ask, and I don't know the answer to this question, so please forgive me. I'm very serious about this. How do you feel about testimony on TV? So-and-so got me $300,000 for my injury case. How do you feel about that?
Well, I think that there's a certain truth to some of it. And I think that you need, here, when you call a lawyer who's advertising on TV, the question you ought to ask is, who's going to be handling my case? Is it you? Or is it one of the guys who work for you? Or are you sending me out to another law firm? There are some guys who advertise on TV who don't practice law at all, ever. Those aren't the guys that you want to be calling. You need to call somebody who knows what they're doing and can give you the value of their experience.
And people can research your verdicts if they want, can't they?
Sure, you can go to my website at goodmanacker.com and you'll see the things that we've done.
Yeah, I noticed when I looked at your website, you refer to a number of verdicts that your firm has had, which I think is really important for people to know about your results. We don't win all of our cases, do we?
No, we don't. And you'd be kidding someone to tell them that you do. But we have an enormously high percentage of wins. We do two things. We make sure that the people that we're representing are honest and that we can take care of them. And we make sure that we have the facts and the law behind us so that we can win your case.
The same things, would you agree, that we are expected to do in terms of being honest with our clients? We want our clients to be
honest with us.
Thank you, and thank you for coming.
My pleasure. Thanks for having me.
You're welcome. And thanks for listening to Law Power Hour. We'll see you next week.